You ever find yourself saying, or having to explain to somebody said, what happened? You'd be like, what happened was, that's usually like a long, drawn out explanation of some nonsense that you got yourself involved in that you could have avoided. So we're going to maybe assist you on certain items that could avoid you having to say
what had happened was.
What had happened was.
All right, I'm ready on, I need Miss Moore to start her video. I need Miss Moore to start her video.
I apologize, Your Honor. I didn't know how to do it.
Okay, so you not knowing how to operate the camera, the phone, has absolutely nothing to do with the judge. If you seem to have so much difficulty, that they will request that you physically appear, because if nothing else, you can physically appear, because the Zoom is an option that's given to you. It's not forced right now, so you do have the option with this judge to come down, because if you can see right here, there are actual people sitting in the gallery waiting to be seen or to testify or whatever they have to go on.
That's
so
true. Yeah.
you do have the option. So if the phone is the convenience. So you do need to know how to make sure it works. Make sure your Wi-Fi is on.
Yep.
Make sure your data, whatever you have to do to get it going, or you got to borrow somebody else's phone. You have this court data, whatever. They will tell you. They even have a Zoom room in the courthouse.
Yep.
From what I'm been told, because so to say you don't know how to do it, I'm quite sure you can find somebody that knows how to do it.
Well, part of the thing that it says clearly that ignorance is no excuse for the law, for not knowing the law. So they don't take the fact that your ignorance, you don't know how to operate it, that's not acceptable. That still can be considered contempt of court. Remember, this is post-COVID, and this has changed the whole game. And this is now convenient, and people still can't get it together. It's amazing. You can not have music playing in the background. That's just madness right there. That's crazy.
Like, are you on hold for something else? You cannot have these things going on. Like, you cannot have something else going on. You cannot have, like, you can't say I'm gonna call my phone company and be on hold while I'm waiting. You cannot do it, because you can be called at any time.
I'm just trying to pay a bill.
You just can't. You can't do these things, because whether you realize it or not, they're all seen as being in contempt of court. If you're sitting in the gallery, if you're sitting there and the judge is talking to you, you can't be looking at your phone. You can't do anything. The judge, and this judge here, she's very, very, very I don't want to say lenient, because she's very merciful. She's very fair. From the cases that we're gonna go and show you, she does work with you, but she can't work with nothing. You have to give something, because at the end of the day, she's here to enforce and to show you the law and explain it to you, what you've done wrong and the consequences of what you are. And you're there to explain why, what had happened, what caused this, reason what happened, or whatever. And from there, she can advise you on what your suggestions are. Now, depending on the case, and depending on the crime, and depending on whether it's a violation or whether it's an actual, what's considered a crime, then you would have, the dealings. So then now, this is when it comes into play. But I'm going to say this, whether you realize or not, your behavior in court tells a lot about how the judge can deal with you, because you throwing yourself on the floor and throwing a tantrum and everything like that. The judge will say, oh, lock them up, because nobody wants to be bothered with this, because you just showed that you're not willing to be worked with.
Right. Not knowing is one thing, and straight disrespectful is another thing. Unfortunately, this is what had happened on it right here.
Ma'am, yes, you did know how to start your video. let's just move on. Let's move on. Just don't do that.
You know, like, not to be funny, you make yourself, so you know, then it's like, whether you realize it or not, you putting yourself, like, if she lied about it. I'm not saying she did lie about it because I don't know her circumstance, but it's like
It gives the appearance of being blatantly disrespectful.
So you got to really measure yourself when you know, like, she's dressed appropriately. She has a blouse. She has a jacket on. You know, she's presentable and everything. She has a background blurred, so you don't really know which is fine, because, you know, she can be sitting anywhere. You know, she could be, you know, she could be at work. You know, who knows where she's at?
Or the line of the bank.
She could be at the line of the bank. Who knows where she's at? But you know, she has it blurred, so you can't really tell where she's at, which is also respectful too, because you know, you could be in some places that, and then also, you know, you have some places that do not really want you to be recorded, but you know, you just have to be there because maybe that's where they have Wi-Fi. So you may be at a coffee shop or whatever, but you don't want to include them in what's going on.
This is case number 214548501, the People versus Regina Octavia Moore. Defendant is charged with assault or assault and battery, and today is the date set by Judge Baltimore for a probation violation hearing.
I don't know why the person is getting up from the gallery over there on the side, but it looks contemptuous because you don't see no one but her, and she's just standing up in the middle of the judge talking, and you cannot do things like that. There's a certain amount of code of conduct and decorum for the courtroom.
She could have to use the bathroom. You know, I mean, things happen. We're human beings, and we have physical reactions to things. She could be not feeling well or whatever. But, you know, usually what you try to do is you try to make sure, especially if you're going to physically be in the court, you use the bathroom, you do everything you need to do so you can you basically have to just sit there and wait.
Yeah, and there's a court officer still there physically at the court. You can get his attention. You're not in contempt of court. Go ahead.
What's going on? And you can say, oh, I need to use the bathroom, and they'll say, okay. Because especially if you are involved in this actual case
and you're on camera,
you cannot leave until you're dismissed. Sure. Because your testimony can now be invalidated, which means that they'll say, well, she's not here. You could have been there for 5 hours, and the 3 minutes you need to be there, you left. They'll say, okay, well, now they may wait for you, but they may not.
Ms. Ritter, your appearance, please.
Now, this is the complaining witness right here. She's coming to the podium, but she was not called to the podium. So that can be seen as in contempt also. So you're not supposed to come up until they call you. So even though they said your name or whatever, they'll say is Jane Doe, is John Doe, is, you know, Baby Doe, is this person here? And then you'll say, I'm here, Your Honor. And then they'll say, okay. And then they'll tell you, well, just stay right there, or whatever. And then at that point, you can say, Your Honor, I really do need to use the bathroom. I've been waiting for some time or whatever. And then they may say, okay, well, we'll call a recess or whatever, because the judge has seen that you've been sitting there patiently waiting or whatever. You know, but once again.
Or you'll get checked and say, you should have did that before court started. Yeah, you can't go to the bathroom now. That's on you. You got to hold yourself.
So, you know, it might, you know, but this is when you might say that if you have this issue.
For the record, Your Honor, Christina Ritter on behalf of the people, the complaining witness.
What's going on in the courtroom right now?
Complaining witness,
this is an easy way to get found guilty. Even if you're innocent, you're looking really bad in the eyes of the court. This just looks like blatant disrespect, because she is sitting there the whole time muted. You could have took care of your business and muted whatever you got in the background. They don't want to hear nothing. This is the problem, unfortunately, with now going remote and having the option of Zoom. It's great, but people get simple and they don't stop and actually just think and about the fact that had you been in court, there'd have been no music in the background or no TV in the background.
Yeah, there's no TV in court. There's no Facebook in court. No Instagram, Snapchat, TikTok. There's YouTube because they're recording. But you cannot be on your phone. Like, that's why if you go, they'll tell you to bring something to read, something quiet for you to do or whatever, so that you can sit there and kind of stay alert or whatever. You know, I've seen people even sleeping in the back, but I don't know. I don't know how that case turns out. So.
Podium. Okay. Ms. Ritter.
Thank you, Your Honor. The complainant witness is in person in the courtroom. Ms. Robinson, speaking to the podium and state your full name, please.
Jackie Robinson.
All right. Ms. Moore, state your name. Unmute.
How do you say Regina Octavia Moore?
So see, if we would have just allowed things to proceed, the person that's here to represent this person, this lady, Miss Regina Moore, is not even here to defend her. So all she has to do is hang back, and she has to wait, because the person who and the judge is saying the person who is here to represent her is not available at this moment, and I'm gonna postpone her case until the afternoon when the person is here to speak for her. So, you know, once again, her not knowing how to do it or whatever, but she did have to show up. And she could just say, you know, I'm here, Your Honor, and that's it. Just hang back.
Ms. Moore, what's all that noise in your background?
Oh, it was the TV. I was in the breakout room. I'm sorry.
All right. Today is a day set for a bond violation. Strike that. I keep saying bond. Probation violation hearing that was set by Judge Baltimore while I was off. And unfortunately, it was not properly set, and the people were not even aware of the situation. Miss Stevenson brought to the court's attention that Miss Coulthurst was the attorney of record. Miss Hauser, I need everyone to be stationary, seated.
I have kids here at home, so.
Okay, well, take care of your kids and come back to court when you finish taking care of your kids. You have a great day and you stay safe.
I'm not saying.
Her off the line. You see, just that fast, she booted the person off the line. Now, here's the other thing. I don't know if you noticed, but she had her arms crossed. The camera was kind of facing up or whatever. It wasn't kind of like directly on her face. So even though she had children in the thing, she could have been off camera while she was waiting and just been, you know, she could have been off camera where you can't be seen, because you can make your camera not be seen. You can you can take yourself off of camera, and she have herself muted and go and check on the kids and see or whatever, and try to put herself in a room where they can do something, you know, put them.
Yeah, she could have muted her video.
She could.
Her name would still be up.
It would still say that she's in attendance, which means you're still there. She's still complying, but now she's dealing with the kids or whatever, maybe getting them something to eat or whatever she's doing. And the judge would not have said anything. The judge would not have known. But you can't sit here and say, I have kids, because they don't. And you know, not to be funny, the judge doesn't have to care that you have children.
Right. Plus, she sounded very disrespectful.
And then you kind of screamed at the judge. You're not realizing you kind of screaming at the judge. And once again, no one's saying you're not frustrated. You're not saying you're not upset, scared, or whatever you're feeling, nervous. Nobody's saying that you're not entitled, that you don't have these feelings, but you kind of have to control these feelings when you're in court, because once again, Judge Bryant is very, 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 but she does demand her respect, and she does. She's supposed to have her respect at the judge, because whether you realize it or not, she's here to interpret the law and to make sure that there's a fair ruling, that they don't just say, that's it, you're going to jail. So she's trying to see a way, once again, like I said at the beginning, to help, to assist, to see if there's some program or something that she can get you, because since you have these children and you do need to take care of them because you're home taking care of them, to see if she can continue to have you be in the same place of having, or maybe even assist you, because she might even say, well, why is it that you're home? You're not working or whatever. You may have a conversation. You know, this may turn out to be a really good opportunity for you, whether you realize it or not, because she may know somebody that know, you know, like they have people in place. Like some of the other things, these people, they do have services. You can ask them for certain services.
Plus, on top of that, also, she also tells you very clearly that she has humble beginnings. She's from the West. She's from a rough area in Detroit, so she's not without understanding of your circumstances. So you can't say that.
That Ms. Coulthurst was the attorney that represented Ms. Moore previously. The court did reach out to the Michigan Indigent Defense Council and asked for Ms. Coulthurst to be appointed to represent Ms. Moore during her probation. And I believe that request was granted. Ms. Coulthurst has indicated that she's unavailable this morning, but is able to log into Zoom this afternoon. So I believe I'm going to just have everyone log into Zoom this afternoon and then set the matter, if necessary, for a hearing.
So see, if we would have just allowed things to proceed, the person that's here to represent this person, this lady, Miss Regina Moore, is not even here to defend her. So all she has to do is hang back, and she has to wait, because the person who and the judge is saying the person who is here to represent her is not available at this moment, and I'm gonna postpone her case until the afternoon when the person is here to speak for her. So, once again, her not knowing how to do it or whatever, but she did have to show up. And she could just say, I'm here, Yana, and that's it. Just hang back.
After the people have had an opportunity to review the evidence. Ms. Ritter?
Judge, thank you. So, Your Honor, the court is correct. The people have not had an opportunity to review the evidence relating to this hearing. I did have an opportunity to speak with Ms. Robinson during a brief break from the court. Ms. Robinson being, I guess, agitated with how the people wanted to proceed as far as holding this probation violation hearing and giving the people an opportunity to give a sound argument and decision in making with this process. She wasn't satisfied with what the people were trying to tell her. So just so the court is clear, and just so Ms. Robinson is clear, it is up to the people. From my understanding, it's up to the people as to how they're going to proceed after viewing the evidence, whether they're going to proceed or not to a probation hearing. And from my understanding, Ms. Robinson has been in contact with Ms. Lurst. So Ms. Robinson is, I guess, has confidence in the probation as to handling this hearing opposed to the people.
Ms. Lurst is not an attorney today. She wasn't one yesterday, and she won't be one tomorrow. I could care less about how Ms. Lurst wants to proceed.
So, right now, we have a breach of ethics.
So now
we have the probation officer has no business talking to the complaining witness. It's not how she's supposed to be in touch. When you file a case, you sign an affidavit. You have to go to the police, they get involved, and they can arrest. Or you go down to the court and speak to the district attorney on how to process it. So right now, we have a breach of ethics because the probation officer is telling her how this is supposed to be proceeding.
And the probation officer also has evidence against their own client. So that's kind of a conflict of interest also. So she's sitting there saying the video or whatever, like nobody even knows what this video is. Nobody's seen this video except this probation officer who's not physically here in attendance for the court, or even on the Zoom camera to sit there and say, well, this is it. And if you hear the judge says very clearly, the probation officer could have a law degree, but they're not practicing and they're not the lawyer of record at the time or whatever. So,
and this is a breach of ethics.
This is a breach of ethics, and technically could get the whole case thrown out. Get the whole case thrown out based on that. And even if this person like assaulted and beat this person within an inch of their life, they could now have the whole case thrown out.
And the problem also, she did not talk. She hasn't spoken about any of this information to the district attorney. She's not even talking.
She's supposed to tell the district attorney. She should have told the district attorney, well, did you know or whatever? Like, did you know that I sent the video or whatever of what happened to the probation officer? And they'll say, no or yes or whatever they and then they have to fill out like basically a form to receive the information, to review it, to see if it's considered, because it has to be what's called logged into evidence. Yeah. This is based on my my Law and Order TV degree of having watched almost every episode of Law and Order.
And based on the actual law enforcement experience of having done this stuff, I'm here to tell you that that's actually true. It's called a chain of evidence. And on top of that, also, this is also a straight violation. First of all, it seems to me like she has a vendetta against the defendant because she's evidence to a parole officer. Only time you do stuff like that is to get that person in trouble with the parole officer.
And the fact that this person did whatever research, because I'm going to call your parole officer. Like, how do you know who her parole officer is? How do you know who this person's parole officer is?
Because you can actually look it up.
I mean, you can look it up, but the diligence for you to look it up and find out who it is, the same way you did that, you could have gave the video to the DA.
That's extra, yeah.
Yes, maybe this person thought by just giving the evidence directly to the this video directly to the parole officer, they could get them violated immediately. But it seems like this parole officer is willing to work with this person as well, because they could have just violated it, but they like, no, let's let it go through the machine of the court.